Creating an official last will and testament in Maryland isn't always a difficult task. In fact, provided the right guidance, drafting a will can be rather simple and straightforward. And best of all, it can be done without seeking counsel from an expensive lawyer. In this video, we'll discuss the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Maryland, and how and where to create an official will. Let's begin by looking at wills and their importance. A last will and testament, also simply known as will, is a legal document that states in writing how an individual wishes to distribute their estate among family, friends, and other beneficiaries after death. It's highly recommended that all adults create a will, particularly those that are advanced in age. Now, let's consider what occurs if no will is left. A person who passes away without a will essentially loses control of who inherits their property. Instead, Maryland law will dictate how the deceased's property will be managed, usually passing to the deceased spouse, children, or other close relatives. Disputes between loved ones can arise when beneficiaries and their share of the estate are determined by state law and not the person to whom the property belongs. It's always in good practice to draft a clear will document, and often without an expensive attorney required. A person of sound mind can draft a written will in Maryland with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's briefly review legal requirements in Maryland. Last will and testaments in Maryland must be signed by the person to whom the will belongs, known as the testator, in the presence of 2 or more trusted and competent witnesses. Though optional, it is recommended that witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or to receive a share of the testator's estate. Once created and signed, wills can be registered with Maryland's Office of the Register of Wills for safekeeping. We're eForms, the biggest database of legal documents. We have created last will and testament templates specifically designed for Maryland that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.